Today's kind of an extra special bonus session. Simply with these new regulations around vacancy taxes and foreign buyer bans, we felt it was super important to get David in here sooner rather than later to talk on these topics, because these things are happening now. So with no further ado, I'm going to give it on over to David Korman.
Okay, thanks, Don. And you're bang on with that. Like, these things came into effect January 1st this year, so we thought we better get to this use sooner as opposed to later. And in order to do that, I'm going to apologize in advance because there's a lot of material here, because we want to combine both of these into one session. So I'm going to try and get through it in an hour, because we just want to make sure you've got this information, because it will affect how you're going to deal with things as a real estate agent. Aside from certain things you have to just know for your own personal situation. If you happen to own a property in the city of Toronto, you're certainly going to want to know about the vacant home tax, but you're going to get questions from your clients too. But it also affects how you're going to be drafting agreements of purchase and sale, and what you should be considering when you're drafting agreement of purchase and sale. And the same thing with the foreign buyer ban. We did some of these webinars last year in anticipation of the act coming into force January 1st, but we didn't have all the information because the regulations weren't passed. So I'm going to get into that too, because now the regulations finally got passed on December 21st, like literally 10 days before the act came in. So no one's had time to digest it or really understand it. But anyway, so we're going to give you this overview. I'm going to get through it as fast as I can with as much information, but you'll have the material available to you as a resource. So let's get into it. I'm going to skip right through all the usual intro slides that those of you that have attended these before are already used to it, and you know how to get a hold of us and where to find us. And please reach out anytime to contact us. And a reminder to check out David and Real Estate podcast. We've done some recent podcasts where we're discussing these topics and some other topical things. So just look it up. Go to YouTube, Kormans search, and you'll see we have a channel there, and all the information is available to you there. So I want to get right into our first slide here, because I know we got a lot of slides to go through. So we're going to start with the City of Toronto's vacant home tax, and we'll get to the foreign buyer ban in the second half of the webinar. So this vacant home tax, it started in 2021. City of Toronto decided they wanted to implement this, and their stated goal was to try to increase the supply of housing, because they thought they know there's a shortage of housing in the City of Toronto. And remember, this is just the City of Toronto. It's not Markham, it's not Mississauga, it's not anywhere else in the GTA. This is just the City of Toronto. So they thought we got a supply shortage. And we have a feeling, although we don't know officially, there's a bunch of properties that are owned by people that are just sitting vacant. And for various reasons, there's owners that they aren't renting it out, or they're not living there. And they decided in their wisdom that we should tax those properties. If it's vacant, we should apply a tax to it. So therefore, they created this vacant home tax. So it came into effect a year ago, so it's really effective for the calendar year 2022, but you start paying in 2023. So we're going through a process now where they're going to collect a tax from anybody that had a vacant home in 2022. They've got to make this payment in 2023 to pay for the tax from the prior year, and that's the way it's going to be going forward. You're always going to be paying in the subsequent year for whatever happened in the previous year if the property was or was not vacant. Okay, and they're stating that when they get this pool of money in, they're going to use it towards affordable housing initiatives, whatever that means. Okay, so the whole idea is they really want to encourage people not to leave properties vacant. So rent out your property, either live in it or rent it out. And either if those happen, you're not paying a tax, and that would help alleviate the shortage. But if you're not doing either of those, then we want to tax you on it so we can use the money. So you're allowed to be vacant, but it's going to cost you, and you're going to have to pay this tax. We're going to use that money to create some other affordable housing initiatives, which we don't know what they are or exactly how they're going to spend it. And I don't think they have any idea yet how much they're likely to collect, and they won't know. And they don't think they know how many properties are actually vacant. And they don't know, and they don't know how to police them. but they've implemented this. So all I can tell you is what we know and how this is going to work. And please don't shoot the messenger, because if you want to know if I think this is a good, bad idea, you may already have figured that out by my tone and the smirk on my face. But let's go through and see what we have to do. So every homeowner of residential property in the city of Toronto has to file an annual declaration to explain what the occupancy status of their property was in the prior year. So that's everybody. You own a home in the city of Toronto, you have to go through this process of filing a declaration in the following year. Okay, so they don't know if there's 2% vacancy, 5% vacancy. They'll figure that out eventually. But what we do know is 100% of owners have to file this declaration to make a statement how the property was used in the prior year. Okay, so now we're in early 2023. We're going to be filing a declaration for the prior year. Okay, and we're going to be paying based on whether it was vacant in 2022. Okay, now the property is going to be considered vacant under the bylaw if it wasn't occupied by the owner or somebody that's considered a permitted occupant as their principal residence. And we'll go through and break this down in a minute. Or if it was unoccupied for a total of more than 6 months during the previous year. So if it was only unoccupied for 4 months, there won't be a tax payable if it was occupied the other 8 months. But once you get to that 6-month threshold, that's when they consider it to be vacant. But you still have to go through this filing process to determine that. And it's 100% of properties that have to file this thing. Okay, so the amount of the tax, because that'll be your first question, like what's this going to cost? So it's 1% of whatever the current value assessment of the property is from the assessment roll, the property tax assessment roll. So just for example, if it's $1 million property, and how many properties in the city of Toronto aren't $1 million these days, it seems. But if it's $1 million property based on the assessment and the tax roll, there'll be a 1% tax if it's vacant. So that's $10,000. You know, so it's not a small laughing matter. It's a $10,000 tax, and this is in addition to property taxes. It's not something that's, you know, if you're already paying property tax, this is something extra over and above normal property taxes. If it's vacant, 1% of the value. $500,000 condo, 1%, $5,000 that you have to pay if the condo was vacant. Okay, it wasn't occupied. So the tax is payable on May 1st of the year following. So if anybody had a vacant property in 2022, they're going to be filing their declaration by February of this year, but the payment has to be paid by May 1st of this year. And this is again payment for the prior year. So let's just break it down a little bit more in terms of how they define some of these terms. So an owner is the registered legal owner of a residential unit. So that's who has to file or make this declaration. Okay, the registered legal owner of the residential unit. And what's considered a residential property? It's a property or a portion of a property that's classified as residential property in the most recently returned assessment roll as of the payment date. So that's the definition that we have. And a residential unit can be a residential property that can comprise one or more self-contained units. So there could be a property that it could be a mixed use property, but a component of it is a residential unit. It might fit this definition. So there has to be a filing, a declaration on that, and there's potentially tax payable if it turns out to be vacant. And there's also a definition for a self-contained unit, which would be a dwelling unit, which includes a dedicated washroom and kitchen. So they're looking for a breakdown of potential mixed use properties and properties that have more than one unit in them. And you got to break it down as to what might be considered a self-contained unit. If it's a self-contained unit, then you have to do a separate declaration for that. So what's the definition of a vacant unit? How does something considered to be vacant? So it's considered vacant if for more than 6 months during that year. So we're just talking about 2022. If more than 6 months in the calendar year 2022, it's not being used as either a principal residence of the owner or another occupant, or occupied for a residential purpose by tenants for at least 6 months of the year. And it doesn't have to be the same tenant, because you could have tenants that switch over. But as long as in the aggregate, there's tenants occupying for at least 6 months, and it's not considered vacant. Okay. Now, a property will be deemed by the city to be vacant if the owner doesn't file the declaration of the occupancy status. If they just don't do it, or they don't provide the backup information that's required as part of the evidence for the city to verify what the occupancy status will be. And I'll get into that a little bit more, because in addition to filing a declaration, you also have to have the backup. And in certain cases, you have to submit the backup right then with the declaration. Other cases, you just have to have it available so that you, if you get audited, you can then produce your evidence that what you're telling them in your declaration is true, because some of these will be audited and they'll go after you on that basis. So just keep that in mind a little bit. So the due dates, I think I mentioned it already, you have to do this declaration by February 2nd. So this is the first one we're coming up to. February 2nd is only a couple weeks away. Everybody has to file that declaration by February 2nd. Some of you may have been fielding inquiries. I know we've been getting it from clients all the time. And we've actually, have a standard response that we prepared to give to clients. And if anybody of you needs something like that, please reach out and we could get that to you, because we're giving them, we put together a list of frequently asked questions and and the links to make the filings and do the declaration, sort of a summary. So, because a lot of clients are saying, what do I do? How do I do this? And it's really not that difficult. You click on a link, you go to a portal, you gotta complete it and submit it. But where it gets a little more complicated is when you have to put some backup information, or people aren't sure what they're supposed to be declaring depending on their status. And we'll get into some of the options in a minute. So anyways, February 2nd, you got to file the declaration, everybody. Okay. If there's a tax payable, because it is a vacant property, the tax has to be paid by May 1st of this year. Okay, so make sure anybody that owns City of Toronto property, that they're getting on that portal and filing a declaration before February 2nd of this year. And again, if they don't, then it's deemed to be vacant and that 1% tax is payable. Okay, so everybody should be doing it. So there's a breakdown of types of occupancy status. So there's basically these categories here. So the property could be occupied as a principal residence with a homeowner. That's the more obvious one. But they've got to be residing there, and it has to be their principal residence. So that's where they should be receiving mail, paying their bills. An owner can't have more than one principal residence. They can't say, oh yeah, this is my principal residence. I also have another principal residence. I'm occupying both of them as my principal residence. It's got to be one property that is their principal residence. So now, if it is your principal residence, you can leave for periods of time for whatever you have to leave for, and without incurring the tax. It's just if the aggregate law turns out to be more than 6 months, then you may have to provide an explanation as to what's going on there. But if you can establish this is your principal residence and there's no other principal residence, you're not going to have to pay the tax. Now, the second option is it can be occupied as a principal residence of someone that's considered to be a permitted occupant. So that's someone that's authorized by whoever the owner of the property is to use it as their principal residence. So it could be another family member, it could be one of your kids, a cousin, a friend, as long as you're authorizing them to use it and they are using it as their principal residence. So this category doesn't include tenants. The third category is a tenanted property. So it's occupied by someone pursuant to a written lease agreement. It has to be for at least 30 days. And each lease agreement, if it's going to be occupied, or you're going to establish it was occupied for more than 6 months in the prior year, each one of those lease agreements has to be for a period of more than 30 days in order for it to qualify as being occupied during that 6-month period. And again, it has to be occupied for residential purposes, not for commercial purposes or office purposes. Someone's actually got to be living in there. Okay. And it's got to be occupied by one or more tenants for a total of 6 months at least throughout that year. And that, again, that's in the aggregate. It could be different tenants coming and going, but as long as they're on these lease agreements that are at least for 30-day periods, because you're gonna have to put all this back up and send it all to them if they want to see it as evidence that in fact it was occupied for at least 6 months by one or more tenants during during that year.
So
Okay.
David, can I just ask
Yep.
a question there? So that means
Sure.
if you have a second property that you're Airbnb-ing out, would that may not qualify as tenanted because your Airbnbs probably aren't for 30 days at a time?
Exactly, Don. That's a great point, because if it's Airbnb, there's very few that are really going to be for 30 days or more. If it's really for, there might be some, but if those are your facts that it is an Airbnb and someone does occupy it for 30 days more, then that lease to that, over 30 days would qualify as part of the 6 months of it being occupied. And as long as you got 5 more months of leases that are at least 30 days that you can put together, you say, look, I've got at least 6 months where it was occupied under a lease for 30 days or more.
I feel like part of what
It's
they're
hard
trying
with
to
an
do here is shut
Airbnb.
down Airbnbs, actually.
Yeah, it's going to be very hard. So
another-
Airbnb owners may, in fact, if they can't put that together, they're going to be paying this tax.
Okay, I have
Yeah,
one
that's
more
gonna be
other
the
example,
cost.
if you don't mind me asking.
Sure.
So friends of my sons, they are quite well off, and they have a beautiful house out in the country somewhere, and they have a second residence that is close to their kids' school. So they kind of like live in the second residence through the week, but it's not their principal residence. Would that still be okay?
No, because they're saying it's really got to be their principal residence. They can't be living in 2 places at the same time.
Okay.
So, but it's a question of fact. You got to look at each one as you go through this declaration to see if you really fit into that category, or there might be an exemption that they might fall into.
Yeah, because the home, like the
Okay.
second home isn't really vacant. They're both never really vacant, but yeah, it's a weird situation.
But it may not
And
be
we have
leased out enough or occupied enough for it to be considered, but it's a question of fact. So,
Yeah.
you have to walk through it with all the facts and see what happens.
Okay, one more question.
And
from the
again,
group.
this is a year-over-year thing. Every year could be a different set of facts.
So Naseem is asking, you said 100% of owners have to file. So do we have to file for the principal home also? If you own one home and you live in it, do you have to file?
Yes. If you're a homeowner living in your own
Toronto,
home, in the city of Toronto, they're going to bother you every year. You have to do this. Okay. And you'll have the easiest declaration to file because I'm just living there. It's mine. It's my principal residence. End of story. Right. That's the easy, but you still have to file it by February 2nd. And if you don't, you're deemed to be vacant. You pay the tax until you appeal it and undo it. And there's an appeal process, but just everybody's going to get in the habit of filing their declaration by February 2nd. 100% of people have to file it. Okay. So a couple other categories to determine occupancy status. Number 4 here is vacant with an eligible exemption. So there are certain exemptions that I'll go through in a minute that it's vacant, but you have an exemption that sort of allows it to be vacant. And the exemptions, I'll go into more detail in a minute, but includes, the death of an owner, if an owner died during the course of the year, and that's why it was vacant. If there's extensive repairs or renovations going, so it's your property, but you have to move out for 6 months because it's undergoing extensive repairs and renovations that you can justify. So that's an exemption. But again, you're gonna always have to provide the evidence to show this, but that's an exemption. If the principal resident is in care, so let's say someone owns it, it's their property, it's their principal residence, and all of a sudden they get hospitalized, they're gone for 6 months undergoing treatment or whatever that is, there's an exemption for that. If there's a transfer of legal ownership, during the course of the year, like someone, you bought the property at some point late in 2022. Okay, so you only acquired it at that point in time. So there's exemptions there, to that owner not having to pay it, because it should be the prior owner's responsibility to pay that. And we'll get into that a little more too. And occupancy for full-time employment or a court order, those are other potential exemptions. And I'll go back to that in a minute. The other one is if it's vacant or deemed vacant. Okay, so you can just declare the property is vacant. That's easy. The owner says, yeah, I know it's vacant. I'm declaring that it's been vacant and I'll pay the tax. Or the property might be deemed to be vacant if, like I mentioned before, the owner fails to file the declaration by February 2nd. If they fail to file it, the city deems it to be vacant and the tax is payable until you get through some sort of appeal process to undo that. But you're gonna have to pay the tax, go through an appeal process, try and get it back. Okay. Now, the property can also be determined to be vacant if you filed a declaration, you said it's not vacant, and then the city does an audit and they don't believe you or something's not good, and they go back and they say, no, we don't think this was right, and we think it was vacant, and we're determining that it's being vacant, it's now payable. So they have this process where they can review everything. They're going to review these filings that are being made and the backup information that has to be provided as evidence. And if they do a review, then they could say, no, we believe it's vacant, and that wasn't proper, and then you've got to pay the tax, and there could be interest and penalties as well. So you got to be careful and see what type of category you might fall into. Now, there are some built-in exemptions that I mentioned before, and this slide just sort of has a summary that was produced by the City of Toronto. So I've already sort of mentioned them quickly, so I'm not going to spend a lot of detail, but one was, death of a registered owner if the property is vacant for 6 months or more in the previous year because someone died, and they'll need a copy of the death certificate. If you fit under the repair renovation category, then you're going to be providing, copies of building permits and other information to satisfy with the extent of the repairs and renovations and the timing for all that. So yes, you can, renovate your property and it could be vacant, but you're going to have to satisfy the city that that's legit, and here's the evidence to show that. The principal resident in care, if you're in the hospital or something like that, again, yes, that's an exemption, but they want some supporting documents. They're going to want a letter from a healthcare facility on letterhead to justify, yes, this person's been in the hospital for 6 months, undergoing treatment, etc. Okay, if it's a transfer of legal ownership exemption, they're going to want a copy of the land transfer deed to see when the property was acquired. And was it 100% transfer of the ownership and a bona fide to an unrelated person, or was it a transfer just to try and avoid paying the tax? So they're trying to anticipate potential ways people are going to try and get around that. If it's an exemption for the occupancy for full-time employment, the description here, the vacant property is required for occupation for employment purposes for a total of at least 6 months in the taxation year by its owner who has a principal residence outside the GTA. And again, they'd have to show proof of residency outside, and there has to be a signed letter from the owner if you're fitting under, not from the owner, from the employer if you're trying to fit under that exemption. And the last exemption is a court order. Because someone might go to get a court order that may prohibit occupancy of the property for 6 months a year for some reason that I don't know what it would be, but that's a potential exemption as well. So go a little bit into how you file a declaration and make the payment. You basically, you go online, you click on to get into the portal. You need the 21-digit assessment tax roll number. And if you have that, then you should be good to go. And there's an online portal. You click and you go in there. So it's designed to not be a difficult process. You certainly don't need a lawyer to help you do it. You might need a lawyer to help you understand if you fit under one of these exemptions. But otherwise, it's intended, you just go online and do it. And, so that's the easiest way. There's also a mailing option that can be done, and they give you instructions of how to make payment if a payment is required. So that's all available in the portal as well. Now, you should know that there are fines and penalties associated with this. So if you haven't paid the tax on time, there's a 15% interest rate that'll be applicable to the outstanding amount from the date that it was supposed to be paid. And again, it's supposed to be paid by May 1st this year if it was for 2022. Okay, so you file February 1st, but the payment has to be received by May 1st. Otherwise, 15% interest gets charged. And they can also file a fine of $250 could be issued, but they have the ability to fine anywhere from $250 to $10,000 if someone's found guilty of an offense for for failure to make a declaration. So you could be anywhere from $250 to $10,000, or if they find that you're making false or deceptive statements in your declaration, or if you're altering, hiding, or disposing of any records in order to evade a payment of the tax, or you're participating in making any false entries or omissions of information, or if you're willfully in any manner evading or attempting to evade paying tax or otherwise complying with the law. So in addition to that tax 1% being payable, you could be subject to these penalties, and $250 to $10,000 is a pretty big range. So you shouldn't be advising anybody to screw around with this. It's either vacant or it's not vacant, either falls into an exception or it doesn't fall in exception. You got to go through the facts and file declarations properly. Tax is payable, it's payable, better to pay it than to ultimately be required to pay it, plus a $10,000 penalty in addition. So we want to be careful with these things. Now, I mentioned before, there's the city has the right to assess these things and to do audits. So their intended plan is that the city of Toronto will be reviewing these filings and doing assessments and seeing if it looks correct. And they may do supplementary assessments and go back for previous years and see if things should have been paid, and they can do random audits and things like that. So they can go back right now with and reassess for anything within 3 years. And they're going to be asking for backup information if they're assessing this or doing the sub assessment or an audit. They're going to be asking for the backup evidence to be provided as well. So there's assessments and there's audits. So they want everybody, you're required to do this, retain your records for at least 3 years of how your property was used in the prior year. And that's why this is like a real pain in the you-know-what for everybody, because even the homeowner who's living there as their principal residence has to deal with this. But you've got to be careful that if you're filing, and you've got to keep your records about how the property was used for at least 3 years, because they could be doing a random audit on you and they're going to ask for information. So you know, and again, the audit could just be random. They just might be picking people out. You don't know if it's going to be you. And if you're selected for an audit, they'll be asking you to submit supporting documentation for sure. And we've got a list of some of the supporting documentation that you might be asked for. So make sure you keep it around and have it available. They'll want to see your vehicle registration or insurance documents to show that everything is going to that property, that you're saying that's your principal residence. Does your vehicle registration, your insurance documents, does that match up? Any ID from the government, does that match up that that's your residence? Your driver's license say that's your residence. What do your income tax and notices of assessment say as your residence? What lease agreements have you entered into? What does it say in a will or any estate administration documents about where you live and where your residence is? What do your employment contracts say, in your pay stubs, your pay statements, your records of employment? So they're going to ask for all of this information, your insurance information, and they may want additional statutory declarations or affidavits, because they want you to swear to the fact that this is your principal residence, or this is how the property was used, or this is who my tenant was, or this is who my occupant was. So they want you to swear this under oath, so that if it turns out to be false, that you've now committed a fraud, and they can assess you with these big penalties, or you could be charged criminally with trying to defraud the city of Toronto as well. And then there's a built-in complaint and appeals process, you know, so if something, you know, accidentally got missed, or there was an audit, or you're not happy with it, there is a process you can go through to complain or to appeal. I'm not going to go into the details because we're a long way off from anybody getting to that, but just so you know that that's built in there as well. So this is the last point that I really want to get into on this topic before we switch to the next topic, is how does this affect your real estate transactions? What are the implications for your real estate transactions? So if there's a non-payment of tax, if someone should have paid the tax and they didn't pay this tax, then that is going to be added to the property tax roll and can be collected the same way that property taxes are collected. So in essence, it forms a lien on the property. So you got to be thinking of this. If you've got a client that's buying a property in the city of Toronto, you want to know, did they file their declaration for the prior year, and did they pay any taxes, vacant home taxes? Were any payable, and did they pay them? So how are we going to know that? So buyers, anybody buying a property in the city of Toronto, wants to be sure that declarations were filed by the seller and there's no arrears, nothing outstanding. Because if there is anything outstanding, it's going to be added to the property tax roll for that property. And they've now just bought that property, and those outstanding taxes are now payable on that tax roll. And if they don't pay it, then that's a lien against that new buyer's property. Even though it was the obligation of the seller, they should have filed the declaration. They should have paid that taxes. So we've already found out from title insurance companies, like they're going to provide some coverage for this, because right now title insurers provide you with coverage for outstanding property taxes. So that's one of the benefits of title insurance. They said you don't have to get a certificate from the city to confirm that the prior year's taxes or all taxes were paid in good standing. We can rely on the seller just telling us that they were all paid and close on that basis. If it turns out that it's not paid and there's outstanding taxes, the title insurance company will pay the taxes to the city, and then they'll chase the seller to try and recover that. So the buyer's kept whole. So title insurance wants to give coverage for this vacant home tax as well, but they want to receive some evidence to limit their exposure as well. So they want to get confirmation from a seller as well. And they want us to try and get that from a seller to confirm that the declaration was filed and there's no taxes payable. Okay. So, and again, if the transaction closes between January 1st this year and February 2nd, you know, the declaration may or may not have been filed yet. So, but we want to know whether it's been filed. So if it closes between February 3rd and the end of the year, the seller's still responsible, because again, this is for the previous year. Okay, but it's the buyer that'll be completing and submitting the declaration in the year that the closing occurs, because they're the owner of that property. Okay, so that's when they be looking to, you know, click on the exemption that there's a transfer of legal ownership, but they're the one that's filing the declaration. But what we really want from sellers is we want them to provide a copy of the declaration that they did file. And from my point of view, I want them to sign a statutory declaration. If I'm acting for the buyer, I want the seller to provide us with a statutory declaration. They're swearing a document that I filed my declaration prior to February 2nd, and a copy of it is attached to my declaration. Okay, a copy of the declaration, there's two different declarations. The declaration that was filed with the city, a copy of that declaration is attached to my sworn declaration that I'm giving to you, the buyer, and the buyer's lawyer, to confirm that I filed it and there's no taxes owing. That's what I would want as a buyer's lawyer, okay, to satisfy me. The problem we have is a seller doesn't have to really provide that right now, unless there's something in their agreement of purchase and sale that says they agreed to provide that on closing. So we think that this will evolve into probably an amendment to the standard agreement form. But in the meantime, we should be probably putting something in our agreements of purchase and sale to say the buyer is going to do this. There will also be, you know, some negotiation between lawyers until this gets settled, that are going to just want to cooperate with each other and say, yeah, no, that's a reasonable request, because we want the sellers to confirm that they've filed the declaration on time and there's nothing owing. And if they don't want to provide that, that's raising a red flag too. But the best way, if we can address it right now, is to get something into your agreements of purchase and sale to add a clause. And the clause, you know, I'm going to give you a couple examples here of clauses that could be added. And it could just be that they're representing and warranty that they filed their declaration, nothing is owing, or it could include indemnity as well. So I got a couple clauses just to show you, and we're in the process of trying to figure out the proper wording and everything, but we've got this drafted so far. So here the seller's representing and warranting that the property is not a vacant unit or vacant under that code, okay, under this bylaw that was enacted, and the seller has fulfilled their obligations under that legislation. So we want them to represent and warrant that the declaration has been filed and there are no arrears or penalties or fines for the vacant home tax. Okay, that's the minimum that we want them to do. Now we could go a step further, and this is another variation, saying that the seller agrees to provide the following to the buyer as proof or evidence that the sellers fulfilled their obligations under this. So they're going to give us a copy of the completed and filed declaration for the previous taxation year. And they're going to give us a sworn declaration from the seller confirming that they filed it. And that's a true and correct copy of their declaration that they filed, and there's no arrears. Or if there are arrears to be paid, that they will be paid, or they have paid it. And here's evidence that we actually paid the arrears or the penalties or whatever is required to be paid. Because it might be that it is payable. So here's evidence that we actually paid it. Okay, so if you're on the buyer's side, you want that. And I'd like to go one step further. I would like the seller to indemnify and save the buyer harmless from any claims or expenses as a result of the seller failing to fulfill their obligations to file the declaration and pay anything. Okay, because if they didn't do it, and they told us they did it, but it turns out that they didn't do it, that outstanding amount of the tax and arrears, penalties, etc., is going to attach to the property tax roll number, and it's the buyer that's going to have to deal with this. It's sitting on their property. So I think a seller should be indemnifying the buyer for that. So if it turns out that this wasn't true, the buyer can go back after the closing, after the seller who's provided this indemnity. Okay, now it should probably even go one step further, is making it clear that the indemnity will survive closing of the transaction as well. So we're still playing with the language here, but if you can get something into your agreements of purchase and sale, that's great, because then we could, as a buyer's lawyer, I can go back to the seller's lawyer and say, hey, we need this as a closing document. We need evidence. You agreed to give this to us as a closing document. It's right in the agreement of purchase and sale. In the absence of that, we have our arguments available, and we're going to deal with it, lawyer to lawyer, to try and get these things, because we need this information. Okay, so it's really important. And I want to get on to the next topic. I just want you to know, this is City of Toronto. City of Ottawa also has a vacant unit tax. So if any of you are dealing with properties in the City of Ottawa, there's a similar tax that's just coming into effect there as well. So it's not exactly the same, but it's similar. And we just thought we'd give you some of the lists, a couple of the differences here. And I'm not going to go into that now, but it's there for your reference. So I just want you to be aware of that. And I want to get into the 2-year ban on foreign buying of real estate, because it's the other piece of legislation came in January 1st that you have to know about. So this deals with non-Canadians. Okay, and there's a definition of non-Canadians. So non-Canadians are prohibited from buying residential real estate in Canada for 2 years, starting January 1st, 2023. Okay, so it's 2 key things here. You have to fit under the definition of non-Canadian, and it has to be residential property. Okay, so it's not commercial property. It doesn't matter here. Okay, now, they announced this back in a budget last spring, and we waited till December 21st and to finally issue some regulations to clarify what these definitions are. So now we've got a little bit more clarity. So what is a non-Canadian? So somebody is sort of obvious. A non-Canadian is someone that's not a Canadian citizen or a PR, a permanent resident of Canada, or a registered Indian under the Indian Act. So if you don't fit under one of those, you're deemed to be a non-Canadian. A foreign corporation is considered to be non-Canadian if it's a corporation not formed under the laws of Canada or one of the provinces in Canada. So if you're incorporated in the US, for example, or any other country, not in Canada, you're considered to be a foreign corporation. A foreign corporation is a non-Canadian. A foreign corporation cannot buy residential real estate in Canada for 2 years, okay? Also, if you are a corporation that is a Canadian corporation, it's based in Canada, that are privately held, not listed on Canadian Stock Exchange, or controlled by a non-Canadian, that might also fit in the definition of a non-Canadian. Okay, and again, it depends on the facts and how things are held. Other foreign entities or entities controlled by a non-Canadian, whatever, it's sort of a catch-all that they've included in there in the definition. So to break it down a little bit further, for non-Canadian corporations or entities, it's a question of control. Who controls those corporations? So if the equity ownership if there's direct or indirect ownership of equity of 3% or more by a non-Canadian, then it's deemed that that corporation is considered to be non-Canadian too. Or if the voting rights, if it's 3% or more of the voting rights are held by someone that's otherwise considered to be a non-Canadian, then the corporation is considered to be non-Canadian as well. And the third part is control in fact, whether there's direct or indirect control in fact through ownership agreement or otherwise. And the reason they have that catch-all there, they're trying to anticipate all the ways that you are all thinking about right now. How can I get around this, and how can I scheme around this and try and close all the loopholes? What if someone buys it in trust, or I get a Canadian to buy it, but it's really mine, and we do a side agreement, all that. That's all going to fall under this, because they're going to break it down and look to see who actually controls the corporation. And if it's 3% or more, then it's going to be deemed to be a non-Canadian under the Act. So that's the definition of non-Canadian definition of control. There's also a definition now of what's considered to be residential real estate, which is like detached house or similar building containing not more than 3 dwelling units, or part of a building that's a semi-detached row house, condo, that's intended to be owned apart from any other unit in the building. Vacant land. Okay, vacant land that does not contain any dwelling on it, but zoned for residential or mixed use, and it's located within what is considered, there's 2 terms here that you're probably not familiar with, a census agglomeration or a census metropolitan area. And I'm going to show you what that sort of is in a second. But then there's exclusion. If a property is not within one of those census agglomeration or a census metropolitan area, there could be an exclusion. So you're obviously asking, what is a census agglomeration or a census metropolitan area? Good question. Here's what they are. So it's basically, they're trying to say areas that are heavily populated, like big urban centers, are going to be considered part of this. So if you're outside of these big urban centers, then you might fall under an exemption. So if you're some recreational property way up north, outside these defined terms of the CMA or the CAs, then you're probably, you're outside and you'll fall into an exemption. And so they're trying to capture major centers, the big cities, Toronto, Vancouver, etc., but also some of the surrounding heavily populated areas are still going to be part of these areas where you cannot buy residential real estate in if you're a non-Canadian. But if you go outside of this, way up to Timbuktu, then you might fit under one of these exemptions. So I'll show it to you on a map. And again, this is a Canadian thing. This isn't an Ontario or a GTA thing. This is a legislation that applies to all of Canada for some, I don't know, I don't want to get started on that. But for some reason, in Trudeau's wisdom, he thought this should be applied all over Canada. But on this map, it's the yellow and the orange areas that it really applies to, because these are the heavily populated urban centers. So if you're outside those areas, and I'll show you a bit of a close-up in the next slide of Southern Ontario, you could see in here. So, and I know it's hard to read in this, but basically the orange and the yellow areas are the heavy populated, centers, London, Toronto, Peterborough, Ottawa, Oshawa, things like that. If you get outside of that, you may be okay. So even outside of it, like, just in the local market, when you go up to Lake Simcoe, part of the area surrounding Lake Simcoe, sort of on the east or the west side and the southern side of Lake Simcoe, that's closer to Toronto, that's still in the map of the area where you can't buy. But if you're on the northern side of that in a recreational property, you might be okay to buy there. So that's sort of the exemption that's there. So there's other exemptions that they're giving you under this law too. So if someone, this is an important one, if an individual is buying a residential property with their spouse or common law partner who is not prohibited from buying for the 2 years, meaning they are a Canadian, okay, they are not a non-Canadian under the definition, then the fact that a spouse who is a non-Canadian is buying with them does not taint this, okay? It doesn't prevent them. It works the opposite way, okay? NRST dealt with it differently because a non-Canadian contain it or under that act. But if a non-Canadian wants to buy it with their spouse who is a Canadian, no problem. That's an exemption. You can buy residential real estate. You're not prohibited from buying it. Okay. And again, it's either a spouse or a common law partner. So the common law partner, that's that is a defined term, and they'd have to meet the test of whether someone is considered to be a common law partner under the Family Law Act. But if they are, then that's an exemption. Okay. There's also an exemption for temporary residents who satisfy certain conditions. And there's two categories, and I'll go into detail on both of them in a minute, but one is a student exemption and one is a worker exemption. So they might be temporary if they fit the conditions attached to one of those. That's another category of exemptions. And then there's other persons that were prescribed by the regulations that'll be exempt, which includes refugees and refugee claimants fleeing international crisis and other accredited members of foreign missions in Canada. So anybody you're dealing with, they might fit under one of these exemptions, and we got to look at each one on a factual basis to see if they fit. So a little more detail on the student and the worker exemption. So for a student, they've got to be enrolled in an authorized study program at a designated learning institution. So not all learning institutions will qualify it. They have to have filed income tax returns for 5 taxation years preceding the year of purchase. They want to buy now in 2023, but they only qualify as a student if they have been filing taxes for 5 previous years. Okay, and they've got to be physically present in Canada for at least 244 days in each of those 5 years, those preceding 5 years. And their purchase price can't exceed $500,000. And they cannot have previously purchased residential property while the prohibition is in effect. So I don't know if there's anybody that's ever going to fit all these categories, but we're gonna see, because it's a very limited exemption for students. Similarly, for a worker, they have to have a permit to work in Canada. They have to have worked in Canada for at least 3 years in the previous 4 years before they buy. And they have to file income tax returns for at least 4 of the previous 4 taxation years before the year that they buy this property, and they can't have previously purchased. So again, I don't know how many workers are going to fit all these conditions in it. Okay. We already know, like, this is going to be screwing up professional athletes. If you're someone that gets traded to the Leafs, the Blue Jays, the Raptors, you're trying to sign someone in free agency, and they're a non-Canadian, and you sign them, you want to sign a long-term contract, but they say, by the way, we want to sign you to a 5-year contract for the Toronto Maple Leafs, but you can't buy a property in Toronto or in Canada for the next 2 years because you're a non-Canadian. They said, well, but I'm going to be working here on a work permit to play for the Toronto Maple Leafs. Well, that's not good enough, because you have to have filed income taxes in Canada for the previous 3 or 4 tax years. So that wouldn't have happened. So anybody that the Leafs are trying, or the Blue Jays or the Raptors trying to sign as a free agent, or it's a non-Canadian, they can come and play for the team, but they can't own property in Canada for 2 years. They can't buy a property. Okay, they can't lease it with an option to buy it 2 years later, because that doesn't qualify either. So that puts our sports teams, and I always like turning every conversation I'm into sports, that puts them at a disadvantage when they go to try and recruit free agents or make a trade with people who might have an option to they have to approve any trade that they're going to be made. So I don't want to go to Canada because I can't buy a property. I got to rent for the next 2 years, and maybe this law gets extended beyond 2 years, and I may not be able to. I might I have a 5-year contract in Toronto, but I can't own a property. I can only rent a property. So one of the reasons I'm not a big fan of this. There's also a definition of purchase, which we didn't have till the regulations came out, like what's considered a purchase. So a purchase is considered to be an acquisition with or without conditions. That's very important. Of a legal or an equitable interest or a real right in a residential property. That's considered a purchase. So a pre-existing contract, if the obligation, if it was signed prior to January 1, no problem, doesn't fit in. You can still continue and complete that transaction, even though you're closing after January 1, 23, because the contract was signed beforehand. Okay. But anything that's signed after January 1, 2023 is obviously going to be caught by this act. It will apply to assignments and assumption of contracts. Okay. But, you know, conditional contract was sort of the gray area. Like, what if someone entered into a contract prior to January 1 of this year, but it was conditional till some point after January 1, doesn't become firm until afterwards. So we weren't sure, but based on the definition that they now came out with, that's an acquisition with or without conditions of a legal interest. So you acquire that legal interest as soon as you sign agreement of purchase and sale. And so as long as it was signed prior to January 1, even the conditions are waived afterwards, it should not be caught by this, and it should be allowed to proceed. Now there's some exemptions where things not considered to be a purchase. When an interest is acquired as a result of death, divorce, separation, or a gift, if that's how they acquired the interest, that will be an exemption. Again, always a question of fact, and they'll need the supporting documentation to support it. Obviously, if someone dies, they'll need a death certificate of divorce, they'll need evidence of divorce or separation, etc. But that's a potential exemption. It won't be considered to be a purchase. If there's a rental of a dwelling unit to a tenant for the purpose of his occupation with a tenant, like, that's not a purchase, that's a rental transaction. If it's a transfer done under the terms of a trust that was created prior to January 1, there might be an exemption. Okay, if it was legitimately created prior, not a trust that we're going to create today that we're going to backdate to a date prior to January 1. Okay, because again, they're looking for loopholes, they're looking for people trying to scheme and get around that. And you'll see why that's so important in a minute. And the last one is if there's a transfer is resulting from the exercise of a security interest or a secured right by a secured creditor. So as a secured creditor that's causing this transfer, there might be an exception, for that. Now, why am I placing so much emphasis on telling you to be careful with trying to get around this law? Okay, they put in some very strict enforcement and penalties with this legislation. So it's anyone who knowingly counsels, induces, aids, or abets in the contravention of this act by not, or just attempts to do that, is guilty of an offense and liable on a summary conviction to a fine of up to $10,000. So that's anyone. Okay, that's not just the buyer who's trying to get around it. Okay, it's not just your foreign non-Canadian buyer that's trying to get around it. It's anyone who's helping them or attempts to help them in getting around this. Okay, so that includes me and you in our rules. Okay, if it's a corporation that commits an offense, that in addition to the corporation not being allowed to go through with this and be subject to penalties and etc., the directors, the officers, the managers, the supervisors, the agents, anybody who's involved in the process who may have participated in this, and again, it's knowingly or attempts to do it, okay, could be personally liable for this offense. So it's not just the entity that's trying to get around this legislation, it's all the rest of us. So this liability could go to developers, okay, that get involved, even helping a buyer that they knowing or should know is trying to get around this. It could apply to a seller who's trying to, who wants to do the deal with a non-Canadian buyer, assignors, lawyers on either side of the transaction, other professional buyers, you as a real estate agent, notaries, mortgage brokers, anybody that's providing services offered in connection with residential conveyance that's part of this, that participates in any way, each one of us can be subject to this $10,000 penalty. Okay, and it's not like, well, if the agent was involved, so the agent's getting penalized $10,000, but if I'm the lawyer and I help them, I'm subject to that as well. And I've told this, we've gone through our clerks, a clerk in our office can be subject to this if they're giving counsel to try and here's a way that you might be able to get around this. Okay, so everybody that's involved in dealing with a transaction has to be very careful. We're allowed to advise our clients and give them the right information. and see if they fit under an exception or an exemption or what the facts actually are. But we can't try and help them get around it if they don't fit one of these things. So this creates a potential conflict for you as a real estate agent, potential conflict for me as a lawyer. Okay. You know, what if you discover that the buyer under a contract, under binding contract, is a non-Canadian? Okay, so that transaction is not going to go ahead. It's not going to be completed. Okay, so you know that contract is going to be terminated, and even after the fact, it can be terminated because a non-Canadian cannot complete a transaction. Okay, if someone is deemed to be non-Canadian, so you know it puts us in a conflicting position. You know, we're refusing to complete or advise in the completion might be a breach of a contractual and professional obligation that we have. You know, we got to be careful with your RICO laws and your duties. Who's your duty to? Your duties to your client, but you have to act in good faith and you have to be above board and you can't mislead the other side on these things. You got to be careful. Same thing as a lawyer, we've got to be careful in what we're doing. So how do we take some steps to avoid knowingly assisting and being willfully blind? Because you can't just be willfully blind. You can't say, you know, I don't want to know, don't tell me, I don't want to see it. Okay, that's not enough. Okay, we have to do some due diligence. You as an agent, me as a lawyer. I think the way this is drafted, because they're saying you can't be willfully blind, means you have an obligation to ask questions and know your client and see what's going on. So how do we want to protect ourselves? Well, what about getting representations and warranties from the buyer, whether they are a non-Canadian under the Act? Okay, we want the buyer to provide a rep and warranty. They've considered the terms of the Act. They've been counseled on it. They've got legal advice on it, and we're representing warrant that we're not non-Canadian. So we're allowed to buy this property. Okay. Do we want to go further and get indemnities or rights of termination that if it turns out that they are non-Canadian, if it turns out they're false, the deal is off? Okay. What reasonable inquiries are we making to buyers, whether they're non-Canadian? So if you're an agent acting for a buyer, don't you want to know whether your buyer client, you're dragging around over to buy a property, whether they're non-Canadians or not? Because if they're non-Canadians, transaction's not going to happen. And if you're helping them, you might be subject to penalty too, but the transaction won't happen. You won't get a commission. Why are you going to waste your time? So if you're on the buyer side, you want to be pretty comfortable that your buyer is not a non-Canadian, that your buyer can go ahead with this. Okay. Otherwise, why are you going to waste your time and expose yourself to a $10,000 penalty? If you're on the seller's side, okay, I'm selling this property. I got 3 potential buyers putting in offers. Wouldn't you want to do a little bit of due diligence to try and figure out, you want to know from these buyers, are you all Canadians? Are you allowed to buy this property? How about if we put a clause right into our agreement of purchase and sale where the buyer represents and warrants that the buyer is not a non-Canadian. So the buyer can complete this transaction and the buyer will indemnify the seller and all of the seller's people that are part of this process. Their agent, their mortgage broker, their lawyer, their accountant, etc. Indemnify us all, because if it turns out you're telling us a falsehood, we don't want to be subject to penalties. So we want to at least be indemnified by the lying buyer. And what if they say, no, I don't want to sign that? Isn't that giving you a red flag? So again, on this, we're in the process of trying to draft up a clause that will go into agreements, and we've got one in the works, and we can reach out and I can share what we've got so far. And I'm sure others are probably trying to do that too, because we would want to know that information, and we want the buyer to give us, like, you don't want to waste your time with a buyer if you're selling that's a potential, you're subject to the transaction not being completed because it turns out they're a non-Canadian and they can't buy this property. So want to just let you know how we finish this. If a transaction gets terminated, or it turns out a transaction was completed by someone that wasn't allowed to complete it, the minister can step in and apply to the court to get an order to sell that property that was purchased in contravention of the Act. So now the government can step in to sell that property. how much commission do you think you're getting on the sale of the government selling this property, right? So we don't want to go there. You know, we don't want this to happen. Obviously, we want to avoid this happening. Okay, so the court can order a sale of the property, you know, based on the terms here. There could be costs involved, etc. You know, we don't even want to go there, but that's what will ultimately happen. The property will get resold by the government. They won't sell it for more than you know, than it was previously sold for. They won't even bother to do that. So you know, that's built right in there. But you know, does anybody want to deal with the property and you're gonna, you know, you're on the sales side of this and you thought you got a commission payable and now your transaction falls apart. But not only that, the government's not going to sell the property. So we got to be careful with this. Okay, now I want to just finish up by telling you again, this is federal law, applies to all over Canada. Okay, unless there's an exemption for those certain areas, those non-densely populated urban areas. And this has nothing to do with the provincial NRST, non-resident speculation tax, that we've been living with for a number of years. That was a provincial legislation. Okay, just the province of Ontario, and with a definition of non-residents that had to pay a non-resident speculation tax. And there's been 2 other adjustments since this originally came in. If you remember, it was originally 15% rate, and it only applied to properties in, so this is just a summary, just, you know, for reminder purposes. Originally, it was 15% rate, and it only applied to properties that were in what they defined as the Greater Golden Horseshoe region. And then that changed in March of 2022, and it went up to 20%, and it became to anywhere in Ontario. Okay, there was this tax payable by anybody that fit the definition of non-resident. And then in October of 2022, they increased it to 25% as the tax, and it's still applicable to anywhere in Ontario. So that legislation still exists. Different legislation, different terms, different rules. This is just a bit of a quick refreshment summary of that NRST legislation. So this applies to individuals who are not a Canadian citizen or permanent resident of Canada, a foreign corporation, a taxable trustee. So there's similar definitions of that to what this ban on new law, federal law is, but it's a little bit different. So we got to be careful with it. But we've got to, you know, just check those things out. And again, this is something you're allowed to buy a property if you were a non-resident, but you had to pay a tax. But now if it turns out, if you're considered a non-Canadian under the federal law, you can't buy the property and pay the NRST if it's in an area where the foreign ban applies to. Okay, so, and the NRST didn't apply to all properties. It had a different definition of which residents it would apply to. And then it did provide certain exemptions for nominees, refugees, spousal exemptions. So those still exist and might be applicable in certain fact situations. And there are also certain rebates that exist, and they could still exist, although that's been modified with the change in legislation as well. So depending on the fact situation, that could be applicable too. So I just wanted to throw that out there so you know that the NRST still might apply. And NRST was confusing from day one because just by definition, it's called a non-resident speculation tax. It has nothing to do with residency. It doesn't matter if you're a resident or a non-resident. It's whether you fit that definition, a defined term of residency. Okay, so it's not whether you lived in Canada for a certain number of days in a year, which is residency under the Income Tax Act, which people get into when they're selling a property. Even if you are a Canadian, you sell a property, but you've been out of the country for more days in the year than you were in the country, you might be subject to withholding tax. But for some reason, provincially, they called it a NRST, non-resident, but the definition non-resident really matters not residency at all. It's whether you're a Canadian or a foreign entity deemed to be a non-Canadian under those definitions. So I know it's all confusing, and that's totally different from the definitions we're dealing with this foreign buyer ban. So lots of information there between these two things, but we thought, you know, when talking with Dawn, we thought it was important to try and cover all of it today as best we could in an hour. You've got the information, you've got some resource to look at. You can certainly reach out with questions now in the chat. I'll stick around and answer
There's some
questions.
stuff in the
or-
chat, David, definitely.
I'm sure there is. And, or you can reach out to me. You've got my contact information. You can scan the QR code here and reach out to me privately as well. Okay.
Okay.
What do you got, Don?
First question, does the vacant home tax also apply to condos?
Yes.
Okay.
Yes.
Apart from filing the declaration, how else would they even know if you're living at the property for that long?
Well, that's the problem.
Right.
The city thinks, oh, I know, we think that there's a bunch of vacant land,
They'll
vacant
go out and
properties
hire a
here.
bunch of people to start stocking these properties. I guarantee it.
So that's their other option. They
Yeah.
hire a police force
Yeah.
to go around and check out and see who's living where. And
Hey, look,
seeing
if they were hiring security guards to go knock on doors when people were supposed to be in quarantine, when they had nothing, no financial gain, they'll do it here.
Right. So instead of that, they say, okay, we're going to do this. We're going to require 100% of owners to file a declaration, and then we'll go from there. Let's see what they file. Let's take a look at the declarations. Some of them are going to just pay because it's obvious they have to pay. Some are going to think that they have a way out or they qualify for an exemption. So let's take a look and see if that exemption holds up. Let's see the facts. Let's see the evidence. And some of them are just going to do, we're letting everybody know that we're going to do random audits. So you might get away with it for 1 year because you filed something and didn't pay your tax. You might get away with the second year, but maybe 3 years later, we get around to you and we do a random audit. We're going to go back to year 1 and year 2, and we're going to see the tax was payable. And now you got to pay it with
nail you
interest.
retroactively.
Retroactive, you got to pay it with interest, with penalties, et cetera, et cetera. So they want the word to get out that we can do these audits and keep all your backup documents and your evidence, because we might get to you. And if we do, if you can't justify it, then we're going to, you're going to pay it.
Okay, so regarding the buying prohibition, if somebody has a work permit in Canada, you said no to that, didn't you?
Well, it's a maybe to that, because that's the first requirement. You have to have a work permit, but then you got to fit all the other conditions, which I think is going to be a very limited number of people that are going to fit those other conditions. They got a work permit, but they've already been paying taxes in Canada for 4 of the previous 5 years under previous work permits, I guess, or something. So it's not just what you are in the current year, it's also what your history was even before that. So it's going to be a very limited number of people that are going to be able to qualify for that.
Is there intent here? This is what I imagine it is, that it's to stop people from buying properties and just letting them sit vacant. Like, if your intent is to, even though you're a foreign buyer, but you intend to live in the property or even rent it out, I would imagine that will eventually be okay.
Yeah, that was part of it. They want,
like in Vancouver,
part of it, they want to go after some foreign buyer, wants their money out of their country because it's a better investment in Toronto. Okay, so they want to invest in Toronto real estate, and that's fine. So the provincial government said, yeah, you could do that, but you might have to pay an NRST tax. Okay, but now the city is saying, well, we don't like the fact that there's houses in the middle of the city of Toronto or condos all over the place that are owned by foreigners, maybe, that the people are just, they're just sitting there vacant when we know we have a housing shortage. People want to live there.
There are streets like that where you'll see like 6, 8 houses in a row that are vacant, and they're just like falling apart. They look like crap. And
so they're saying, okay, we're going to pass this. So now you're going to do one of two things. You're either going to pay the tax, and we'll use that money to create some more affordable housing, apparently, or you're not going to pay the tax, but because this law is in place, it's going to encourage you to not just leave your condo downtown vacant and rent it out to somebody. Okay.
Yeah.
So, and I don't think they know how people are going to react.
And it's all kind of stomping on
foreigners that are
property
actually owning it, or just people
so,
invest. They might say, you know what, I'm happy to pay the tax because I don't want anybody living there.
Yeah.
But on the other hand, someone say, you know what, why should I pay on $1 million property? Why should I pay a $10,000 tax when my other option is I could rent it out to somebody and I'll earn $2,000 a month in rental income and not pay the tax?
Okay.
Right? But then there's wear and tear on my property. I gotta be a landlord. There's other factors, but they're giving people a choice. Either rent it out or pay a tax.
Okay, next comment here. Quote, interest acquired as a result of gift, end quote. So would you stop it? So for example, if my client is a young Canadian professional, but with not enough money to purchase, gets financial support from his uncle in China, who is not a Canadian, to complete a purchase by providing a down payment, is that okay? So I
Sorry.
guess the Canadian person would be making the purchase, but the funds to support the purchase would be coming from China.
Yeah, it's going to be a question of fact, because who really owns the property? Does the person in China own it? They're the real beneficial owner. If it was truly, in fact, a gift, and that could be substantiated, so the person in China can never ask for that money back, can claim no interest in the property here, but that just happened to be the source of funds at some point, it might fit, but it's a question of fact. Okay. But the proceeds of that, when that property gets sold, it can never go back to that person in China. You know, if that's the facts, it would have to be a true gift. The money has to belong to the person that's a non-Canadian. Or sorry, that is a Canadian, not a non-Canadian. I hate talking in
It's
double
confusing, right? Okay, now
Yeah,
this
but
is going to get
it
really
has to be
confusing.
Canadian.
If the common law, okay, a couple is common law, one partner is a permanent resident, the other is on a work permit. Would they be considered foreign buyers as long as the primary buyer is the one with the permanent resident status?
Yeah,
Wow,
as long as one of the spouses, okay, doesn't meet the definition of what a non-Canadian is, then they'd be okay. If one spouse is clearly a non-Canadian, but the other spouse is a Canadian because they fit in definition of what a Canadian is, then they can buy it together. No problem.
Okay. Okay, oh, hold on, another one here. Can you please share the frequently asked questions and ANS for vacant properties that we can use? Also, APS, and also the clause we can add to the APS.
Yeah, if you reach out to me directly, I can send that to you.
Okay, everybody know how to reach out to David? It's D Korman
at Kormans with an S on the end .ca.
Kormans.ca. It's in the chat, kids. Okay, any other questions, guys? Don't worry, this is not the last time we're going to discuss this issue. I guarantee it.
Yeah, look, everybody's working through the first filing of the declarations and the vacant home tax.
Yeah, all
everybody's going to be just getting used to the foreign buyer. You're going to have clients constantly, I want to buy a property. Am I banned from buying this property? Do I fit under one of these definitions, one of the exemptions? So some of it you might be able to figure out, it might be obvious, but others, you might have to, retain a lawyer to go through the facts, and the facts are the facts. But the only thing I just caution everybody again, just be careful. Okay. We can advise based on it, but we can't try and help them get around it when we get a whiff of anything that's not right. And we believe they're not good. We got to be really careful because they're putting the onus on us as the advisors to do our due diligence. Okay. And you can't be willfully blind. You can't say, I don't want to hear about it. I don't want to hear the whole story. No, we have to ask the whole story. Okay.
Okay. Bruce has a question as well. Go ahead and unmute, Bruce.
Okay. Yes. Hi, David.
Hey,
in
Bruce.
regards to the foreign buyers tax, right? Just to clarify, the exemptions, they're still paying the foreign buyers tax, right? They're exempted from the ban, but they still have to pay the foreign buyers tax.
You talking about the NRST?
Yes.
Yeah. If they're allowed to buy, if they're not prohibited from buying, because they don't fit under the definition under the foreign buyer ban. So let's say they're not banned.
Yep.
They're buying a property that's not subject to the ban, and it's in Ontario.
Yep.
They might still be paying the NRST.
Okay.
Okay.
And
so if they have to get through the first loophole that they're not banned under the foreign legislation. So now they're not banned and they're buying a property that's not subject to that foreign ban, but it happens to be in Ontario. And if they fit the definition of a non-resident under the NRST definition, then they might be paying that non-resident speculation tax.
okay. And was there a purchase price cap on that? Was that 500,000 or was that just for the students? Okay, so there's no price limit. Okay. And then another question in regards to the vacant home tax. If a client has two properties in Toronto and his parents are staying in one, but they don't have a principal residence, or if they don't own a property, or if they do own one that's in the cottage, do they have to pay the vacant tax?
Yeah, that sounds like that they'll probably fit that one of those categories of occupation that's permitted. 'Cause remember, one was the easy one is the owners occupying themselves as their principal resident. The second one was it's not tenanted, but someone is occupying it with the permission of the registered owner. So the owner is saying, my parents, I'm allowing you to live there. You're not my tenants, but I'm allowing you to live in my property and you're related to me. I'm allowing you to live there and you're using that property as your principal residence. So that would be okay if they're filing, that's how they're completing their declaration. The third category was it's actually rented out to tenants, to third-party tenants, and here's evidence of our lease that's at least 30 days, right? So
Okay.
your factory sounds like it's fitting that middle category where someone's owned it, but I'm allowing my parents to live there, not as tenants, but they're occupying it as their principal residence. So they complete the declaration that way, saying it's being occupied by my parents with my permission.
Okay, got it. So as long as they don't own another property that they're saying is a principal residence,
Right.
there should be a loophole
Right.
there.
If the parents had another principal residence somewhere, then that's not right. It's not good. It'll be caught.
Yeah. Okay. Got it. Thanks a lot.
Okay.
Okay. Any other questions, guys? Going once? Going twice?
Hi, it's Tina. Hi, guys.
Better be one.
Yes, Tina just got in there.
Knew somebody was gonna sneak in there.
Just
Go
got
ahead,
in
Tina.
before the gavel went down.
Sorry, guys. Just a quick question. So I understood if you're a worker, if you want a work permit here, you can buy, so you're exempt, but you have to have the work permit in the last 4 years, 3 years, right?
Yeah, you got to fit all the other conditions that go along with there being a work permit. So
What are the other conditions? So that's one. There's others conditions too.
yeah, it was in the slide. Let me see if I can
Sorry.
access it again, but hang on. Let me see if I can, because I don't remember them all off the top of my head.
If not, I can just send you an email, and if you can send me those information, that might be easier for you.
And Dawn, you're sharing the presentation with people so they can access it again.
Okay, I can find it in there if I can
Dawn,
access.
you're
Yeah.
muted. Dawn, you're muted.
Sorry, I had too many things open. I couldn't get to the right part of my
Okay.
screen. I don't actually have just the presentation, but it's in this video and you can watch.
Yeah, it'll be in the video. Yeah, and I can always send you a PDF version, Dawn, if you want to make that available to people. But basically, for a worker, they have to have a work permit authorizing to work in Canada. They have to have already worked full-time in Canada for at least 3 years in the preceding 4 years. And they have to have filed tax returns for at least 3 of the preceding 4 taxation years before the purchase. So I don't know how many people are going to actually fit all those categories, and they can't have previously purchased a residential property while this prohibition was in effect. So they can sort of do it once, but they got to fit all that. I don't know who would actually fit all of those categories, but someone could, I guess.
David, can you put your
Thank
QR
you.
code back up on the screen?
Hi,
Go ahead, Ken.
I have a question, David. I have my own rental unit. I sold the sold day of my condo December 16, 2022. And then the closing day will be February 2nd. So do I need to do anything?
Sorry, you do that one again?
I sold my rental condo on December 16, closing day. And sign the contract, right? And then the closing day will be this year, February 2nd, not the 3rd. February 2nd. Should I do anything? Do I have to file the record to the vacant?
Yeah, well, it's really the current owner that has to file it.
Okay.
Because they're the owner that has to file, but they'd be saying, I just bought it December 16th, and they're not going to have information necessarily about whether it was vacant prior to that.
But it's not closing until the 3rd.
But before 1 day, because you mentioned February 3rd to December 31st. You said 2022 or 2023? Which year you didn't mention, David?
Sorry, it closed in 2022, or it was signed in 2022, but it closed in 2023. I couldn't hear you clearly.
Signed the contract December 16 and closing day this year.
Oh, it's
2000.
closing when this year?
Yeah, no, February 2nd, closing day.
Oh, it's closing right on February 2nd?
Yeah, because you say the 3rd, right? So before 1 day.
Yeah, well, like that's the day that it has to be filed by, but it's the, you know, the seller would have to be filing it by that day.
Yeah.
Okay. And so the lawyers have to get involved here because the lawyers are going to have to work that out. Because if I'm acting on the buyer's side, I want to make sure that the seller has filed and I get evidence of that they filed and there's nothing outstanding for 2022.
Do I have to file anything? That's my question, you know, David.
Does the buyer file?
Oh yeah, he's Ken's the seller, so.
I belong to seller, not the
The
buyer.
seller has to file for 2022.
So I have to, because last year the whole year is for rental to the my tenant, you know. So
Yeah, but the tenant doesn't file these things. It's the owner of the property that files.
okay. So I
The
think
owner files saying, I owned the property in 2022 and it was occupied by my tenant all year. You know, that's what they're checking off, if it was occupied by their tenant. So there's no
Right.
tax payable if it was occupied by a tenant under a valid lease that was at least 30 days or longer.
where can I get the link to get the form to file to the specific department for the vacant home tax department? Where can I get the
Yeah.
form?
If you reach out to me, I can send you a link to it. But if you Google vacant home tax portal,
Online,
City of
yeah.
Toronto, it's going to come up anyways, pretty easily.
You don't mind to send me the link?
And it's actually in the chat. If you just scroll up in the chat, Andrew posted the link.
He posted it, yeah.
Yeah.
If you Google vacant home tax portal, City of Toronto, it's going to come up like and then you just click in that. And the only thing you'll need your tax assessment number in order to start the process, because that'll get you into your own, you know, to the declaration by the owner.
Where can I find the assessment number by the
Property tax bill.
Oh, I see. I have to call the property tax department, right?
Well, the owner gets a property tax bill. So the owner should have a property tax bill. So that
Okay.
every property tax bill has an assessment number on it.
Assessment number. Okay.
Tax assessment number, yeah.
Is that the link for Toronto.ca service and blah 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 for that one, right? Okay. Okay.
Okay.
Thank you. Thank you very much.
Okay.
Okay.
David,
on?
I have a quick question. So
Oh, there we
just,
go.
just as a follow-up with Ken's question,
Yeah.
if a seller, because of the closing February 2nd, if they don't want to, or they want to avoid doing that, can they just close January 31st? Or that's
Well,
not,
look, this is something that the lawyers involved in that transaction are going to have to hammer out, because if I'm a buyer, I don't want to close on February 2nd unless I have evidence that the seller filed the declaration for the prior year. Okay, so I want to know there's nothing outstanding, and I want to get a copy of it. So they're going to have to work that out, because odds are there's nothing in their agreement for sale saying the seller has to provide that. But if I'm a buyer's lawyer, I want that. And because I want that as a buyer's lawyer, if I'm on the seller's side, I'm prepared as a lawyer to cooperate with the buyer, because I think it's a reasonable request. So the two lawyers involved in the closing transaction should try and work that out.
okay, thank you. Thanks.
Not all lawyers will be as reasonable as me, but they should be. So that's why I'm saying it's better if we start putting this right into the agreement purchase sale, that the seller will cooperate and provide this information. Okay.
Thanks. Thank you.
And just in case there aren't any other questions, we're doing another, next webinar is next Thursday, I think, on things you have to know. You're on the buyer's side of transactions.
Hold on.
Is
Just
the
looking.
topic.
Representing the buyer.
yeah, if things you're representing the buyer, and we'll do another one at some point representing the seller, but this
We
is,
might need to move that one, David. We'll talk
Yeah.
offline.
oh, yeah, okay.
Yeah.
We have to move it, we'll move it, but,
Yeah, we gotta move that one. I
Okay.
have an appointment at noon that day.
okay. All right, so never mind.
Never
We'll let
mind.
you know next week.
Sorry, guys.
And I think we're booked for the following week as well.
We have so much coming up.
Yeah, the following week, which is February 2nd, I think we're doing one on status.
Status certificates, yeah.
So anyways, if we have to juggle them, we will, and Dawn will give everybody notice, and we'll get
Yeah,
back to
instead of being every other week, we're pretty much every week for the next month.
Yeah, we have to move it every other week just to get some of these topics in, and
Yeah.
but
We're
we'll
plugging
keep
holes.
juggling. Yeah. So I hope you weren't all too confused with all this. It's a lot of information in a short period of time, but I think you've got some reference material and you know what questions to ask, and hopefully that helps you.
All right, everybody, have a fantastic afternoon, and we'll see you all later this week. Take care, everyone.